for the fact was that the United States Constitution protects the right to homosexual marriage. His 3 secondary claims were that the Constitution protects our right to privacy, excluding homosexual couples from the same rights as heterosexual couples is unconstitutional, and the Supreme Court ruled that banning homosexual marriage is unconstitutional. For this past week and a half while I was trying to write this thing, I definitely didn't know how to go about it. So this, as you guys know, this topic is very controversial, and it's also very sensitive to some people. So just bear with me for the next couple of minutes. First and foremost, Bob mentioned that marriage is a private matter. In his speech, he stated that who you guys marry is none of my business, and who I marry is none of your guys' business. This is true. However, homosexual couples aren't really trying to keep themselves a private matter. As you guys know, there have been numerous court cases that have been announced to the public dealing with homosexual issues. There are LGBT parades, walks, and marathons. There's newscasts, and even this past week in Russia, there was a riot. They're making it known and they're making it clear to everybody that they're here and that they're here to stay. It's great that they have pride, and it's great that they're passionate about getting equal rights as everybody else, but the fact that they're taking it to such an extent and showing it to the public is kind of catching everybody off guard. This leads me to my second point, which is that same-sex marriage is still very new to society. The first case ever, really, dealing with homosexual controversy was back in the 1980s, and it was Bowers versus Hardwick. This was taken from the actual opinion of the court that is posted on law2.umkc.edu, and this is basically what the court case is about. It said, in August of 1982, Hardwick was charged with violating the Georgia statute criminalizing sodomy by committing that act with another male in the bedroom of his home. Think about it, 1982, that was less than 30 years ago. That's still really not enough time to get people 100% comfortable with this topic. Justice Alito was on the jury for the U.S. versus Windsor case, which Bob had mentioned in his speech. If you guys remember, the U.S. versus Windsor case was when Thea Aspire and Edith Windsor went to Canada and got married in 2007. In 2009, Thea Aspire passed away and she left her estate to her spouse. After doing that, New York started charging them with estate tax, or started charging Edith with estate taxes, so she went to the court case and went to the federal court to challenge it. After this case, the case was actually settled early in 2013, so just a couple months ago, and Justice Alito made the comment that traditional marriage has been around for thousands of years. Same-sex marriage is still very new, and then he asked the question that you want us to make a decision based on an assessment of the effects of this institution, which is newer than cell phones or the internet. That was taken from towelroad.com. Basically, we're still trying to get used to the situation, and the fact that a lot of homosexual couples are just kind of shoving it in our face that they're here has caused an uproar between those who support homosexual marriage and those who do not support homosexual marriage. My last point is that homosexual marriage goes against natural law. When I looked up natural law, this is from dictionary.com, and it says natural law is a principle or body of laws considered as derived from nature, right reason, or religion, as ethically binding in human societies. I took this in a way that kind of meant that this is how society was, and this is how society has been. As Justice Alito has stated, for thousands of years before us, marriage has always been between a man and a woman. The fact that people are changing this basically before our eyes has kind of given people, in a way, culture shock. You can't really expect people who aren't used to this or haven't grown up around this to be completely 100% okay with how things are now. All in all, people's beliefs don't change overnight. Yes, the Constitution does protect our right to privacy, but when homosexual couples are publicly displaying and publicly announcing that they're being treated differently, it doesn't really keep it a privacy issue anymore. People all over the world are still getting used to this, and it's not really fair to place the weight of this issue on the shoulders of those who haven't really gotten used to it. My concluding quote is that you can't allow the majority opinion to outweigh the minority opinion, but you also can't allow the minority opinion to outweigh the majority opinion. Thank
Well, I think you start off pretty well identifying the claims of the advocate and outlining pretty clearly what you're going to talk about. You focused first on the issue of it being a private matter, and I think that I think this is sort of where you make a key mistake here. You're kind of equivocating the issue of it being a private matter with being something that is out in the public, like in your face sort of thing, as opposed to a legal standard which concerns who has an interest in this and whether or not there is a public interest to address this particular issue. And I think that's the key argument there. You kind of go at it in this other direction, which I do think there's a sociological argument that you're making here that says, look, this is a relatively recent change. I mean, you cite the court case that basically overturned laws against homosexuality and point out that's less than 30 years old. When 30 years ago, these were crimes that we were talking about, and now we're talking about making them the standard for a legal contract between people that the government's going to recognize, and that's a short turnaround time, and so there's a barrier there. I think that's a legitimate argument to make. I'm not sure it's the argument, though, that applies to the privacy issue here, which is whether or not there is a legitimate government stake in the decision about marriage and who should marry and those kinds of things. I think you missed the obvious issues on that point, and that is that we have plenty of regulations that control private behavior in the interest of social outcomes, especially in marriage. So, for instance, nobody is challenging the rules in a lot of states that prohibit cousins from marrying. California is one of the states, if you want to, you can marry your cousin. So, if he or she is hot, feel free.
First cousins?
Yeah. But you guys are all turning your nose up at that, but that's one of those things that we say, well, that's a private matter. Why should it be anybody else's business who you marry in this particular situation? If you want to marry your brother or sister or whatever, or how many people you should marry, those are all private matters. And I think that's the way you need to kind of address that argument, because that's the way the argument's been addressed, whether or not there's a legitimate state interest on those issues. You kind of go at it in this other direction about, well, they're in your face and they're parading down the street and all those things. And I don't think that really addresses the legal issue. It addresses that other issue that you develop. And I think you've got a good argument on that particular argument that says, look, the fact that people are uncomfortable with this, or that it's taking us a while to adjust to that, that's natural because it's relatively recent and we're still uncertain as to what its status ought to be. I think that's a perfectly legitimate argument. But his argument is that the Constitution protects this right, and I think that there are good claims that say, the decisions by the court are not necessarily ones that have said homosexuals have a right to marry. They are that the federal government doesn't have a right to pass laws that do this particular thing that violate other sections of the Constitution. It's a more complex issue, and I think you kind of missed the legal nuance on that. But it's pretty well organized, and I thought you did a very nice job presenting the argument, talking to us, and explaining your position on those issues. All right, thank you.